The Supreme Court has just delivered a unanimous 9-0 ruling, and this is not a routine case that slips quietly into the archives. This decision strikes directly at the intersection of the Second Amendment and the Fourth Amendment, two pillars of constitutional protection that for years seemed to collide rather than cooperate. What the court has done is nothing short of historic. For the first time, the highest court has clarified how these rights function when they meet in the real world, especially during encounters between ordinary citizens and law enforcement. The stakes could not be higher because millions of Americans exercise the right to keep and bear arms, while all of us rely on the Fourth Amendment's shield against unreasonable searches and seizures. When those two rights appear to clash, the consequences define the daily relationship between the citizen and the state. For years, lower courts were caught in a tangle of contradictions. In some jurisdictions, the mere presence of a legally owned firearm was enough to justify police expanding a stop, prolonging detention, or seizing the weapon temporarily. In others, judges insisted that officers needed clear and articulable reasons beyond firearm possession. The result was chaos. Law-abiding gun owners could find themselves treated as suspected criminals simply because they carried, while officers themselves operated under inconsistent standards that shifted depending on which circuit issued precedent. This patchwork created not just legal confusion, but real-world uncertainty every time lights flashed in the rearview mirror. Justice Clarence Thomas, writing for the court, made it plain the Second Amendment cannot be demoted to second-class status whenever the Fourth Amendment is in play. The right to keep and bear arms, if exercised lawfully, strengthens rather than weakens the protections against unreasonable government intrusion. The court introduced what Thomas called the principle of constitutional harmony, the idea that rights must reinforce one another, not cancel each other out. This reasoning overturned years of conflicting case law and established a new framework. The presence of a firearm is not by itself suspicious and cannot serve as the trigger for expanded searches or prolonged detentions. To understand why this is such a watershed, recall the 2008 Heller decision. That was the landmark moment when the Supreme Court declared that the Second Amendment protects an individual right to possess firearms, not just in connection with militia service, but for personal defense in the home. That ruling reshaped the constitutional landscape, but it also opened a host of unanswered questions. How would this individual right interact with doctrines built under the Fourth Amendment? Would lawful possession of a gun invite greater scrutiny by police, or would it be treated as a neutral fact no more suspicious than carrying a set of car keys? Different circuits gave radically different answers. In the Ninth Circuit, officers were allowed to detain and disarm concealed carry holders during routine traffic stops, even when there was no sign of wrongdoing. In the Fifth Circuit, by contrast, judges required that police point to something more specific and articulable before they could escalate an encounter. Imagine two citizens, both licensed, both law-abiding, both stopped for something as small as a broken taillight. In one part of the country, that stop could spiral into an intrusive search and lengthy detention, all because of the firearm. In another, the officer would need legitimate grounds beyond the weapon itself. This was not a theoretical debate, but a lived reality, creating a constitutional lottery dictated by geography. The Supreme Court's new ruling cuts through that confusion. By a unanimous vote, the justices declared that constitutional rights are not to be ranked with some yielding automatically to others. Instead, they must be read together, balanced, and mutually reinforcing. This is the framework that now governs every police encounter involving a lawfully possessed firearm. The Supreme Court's ruling did not appear out of nowhere. It was the culmination of years of legal battles, conflicting appeals, and ordinary citizens caught in the crossfire of constitutional uncertainty. For too long, lower courts tried to balance officer safety with individual liberty, and the scales often tipped against the citizen. By stepping in now, the justices did more than resolve a technical disagreement among circuits. They restored clarity where confusion had reigned and reaffirmed the promise that rights guaranteed on paper must also be guaranteed in practice. The cases that converged on the court each posed the same essential question: can the lawful presence of a firearm be used to justify a broader search or prolonged detention? The court's unanimous answer was no. This was not a cautious ruling limited to one scenario, but a sweeping statement that constitutional rights move together. The justices made it clear that exercising one right must never strip away another. For citizens, that principle is more than theory. It is a safeguard in daily encounters with government authority. Justice Clarence Thomas, writing for the court, warned of the danger of a constitutional catch-22, a trap in which invoking one amendment meant forfeiting another. For years, gun owners feared exactly that outcome as courts in some regions reduced their protections the moment a firearm appeared. Thomas rejected that reasoning completely. Instead, he offered the idea of constitutional harmony, the recognition that rights do not compete but complement each other. In plain language, if you are exercising your right to bear arms, your right to be free from unreasonable searches remains intact and even reinforced. The court established three standards that now reshape every police encounter. First, the presence of a firearm by itself does not constitute reasonable suspicion. Second, a valid carry permit creates a presumption of lawfulness that strengthens Fourth Amendment protection rather than weakening it. Third, any search or seizure of a firearm must meet the same constitutional standards as searches of any other lawful property. These rules sound simple, but they sweep away years of precedent that had allowed officers to stretch their authority whenever guns were involved. Before this decision, the experience of a lawful gun owner depended almost entirely on geography. In some states, a routine traffic stop could spiral into a prolonged detention, disarmament, and questioning, all without evidence of wrongdoing. In other jurisdictions, courts required specific and articulable reasons before police could go further. The same citizen acting legally could be treated like a criminal or respected as a rights-bearing individual depending on the circuit. That contradiction eroded trust in the justice system and left both citizens and officers unsure of the rules. Legal scholars are already noting how far this new framework could reach. They predict it will influence challenges to firearm storage laws, magazine capacity limits, and licensing schemes, because the court has underscored that rights are mutually reinforcing. The principle of harmony means that one constitutional protection cannot be sacrificed to diminish another. When combined with recent unanimous rulings such as the rejection of the Fifth Circuit's moment of the threat doctrine in Barnes v. Felix, or the decision to uphold federal rules on ghost guns, the message is clear. This court is drawing sharp boundaries to protect constitutional guarantees. Perhaps the most striking aspect of the ruling is the unity of the justices. In a time when the court often splits along ideological lines, all nine stood together. That unanimity sends a powerful signal that this is not a partisan issue, but a constitutional imperative. For ordinary people, it means the rights they invoke on the street have the same weight as those recognized in the courtroom. For law enforcement, it sets binding directives that cannot be ignored. And for the nation, it marks a reaffirmation that liberty is not a matter of geography or political mood, but a fixed promise rooted in the Constitution itself. The immediate impact of the Supreme Court's decision is being felt in police departments and courtrooms across the nation. Policies that once allowed officers to automatically disarm concealed carry permit holders during routine traffic stops are now plainly unconstitutional. Law enforcement agencies are rushing to revise training manuals, update procedures, and send out new directives that make it clear a lawfully possessed firearm is not a license for government intrusion. In practice, that means a driver pulled over for a minor traffic violation cannot be treated as inherently suspicious simply because they are armed. Officers must now return to the traditional standards of reasonable suspicion and probable cause. For citizens, the change is just as significant. If you are carrying legally, your rights are no longer downgraded the moment an officer notices your weapon. Instead, your carry permit now acts like legal armor, reinforcing your Fourth Amendment protections rather than eroding them. Police cannot demand to inspect the firearm, run its serial number, or interrogate you about weapons without meeting the same threshold that would apply if the property in question were a laptop, a phone, or any other lawful possession. This shift empowers ordinary people to stand more firmly on their constitutional ground, knowing that their rights travel together rather than canceling each other out. The ripple effects extend into the courtroom. Hundreds of prosecutions that relied on evidence from firearm-focused searches are now vulnerable. Defense attorneys are already filing suppression motions arguing that the government built its case on unconstitutional practices. Some of these cases have been dismissed outright, others are being retried under the new standard, and many more are under review. The judicial system is entering a phase of recalibration where prior assumptions about firearms and police authority can no longer be taken for granted. Every ruling from here on will be measured against the framework the Supreme Court has just established. Looking forward, the implications stretch well beyond roadside encounters. This precedent will shape challenges to assault weapon bans, magazine capacity limits, and storage requirements. Courts are now instructed to presume that lawful gun ownership reinforces, rather than weakens, other constitutional protections. That presumption could prove decisive when judges weigh laws that previously survived scrutiny under the idea that safety concerns outweighed individual rights. The harmony principle changes that calculation. Laws will now be evaluated in light of how they affect not only the Second Amendment but also the Fourth and potentially other protections as well. Legal scholars note that the court is setting a broader pattern. By insisting that rights harmonize, the justices are sending a signal that the Constitution must be read as a single integrated charter rather than a menu of separate clauses. This philosophy could influence not only gun rights cases, but also disputes involving free speech due process or property rights where multiple amendments overlap. The doctrine of harmony, though expressed in simple terms, has the potential to reshape constitutional law far beyond the issue of firearms. It is not just a rule for today's disputes, but a framework that future courts will have to respect. For the public, the message is clear. Constitutional promises are not abstract ideals, but real-world protections. Every lawful gun owner who encounters law enforcement now does so under a presumption of legality rather than suspicion. Every officer must adjust their instincts, learning that the mere sight of a firearm does not automatically justify escalation. And every judge must apply a uniform standard that treats rights as cumulative rather than competitive. That shift restores confidence that the rule of law applies equally in every jurisdiction, no matter the zip code. This ruling is not an end, but a beginning. Already 3 more Second Amendment cases are scheduled on the Supreme Court's docket. This term, each one likely to build on the harmony principle. Lower courts will struggle with the details. Legislatures will test the boundaries with new laws, and advocates on all sides will seize on this language to press their agendas. But one guiding star has now been fixed in the constitutional sky. Rights do not cancel each other. They stand together, and when exercised lawfully, they make one another stronger. The unanimous ruling of 9 justices ensures that this principle will echo across decades of constitutional debate and daily life alike.